Good morning to you all. Thank you for attending this joint workshop of Sakpatenti and the EUIPO on the alternative dispute resolution services. So as the President said, my name is Kirsten Bauk. I'm the head of the Boards of Appeal Alternative Dispute Resolution Service. And today I will be very pleased to present to you an overview of the different mediation techniques that we offer to the users of our proceedings in the EUIPO. So if you just patient for a few moments. Let me just share my screen. So as I indicated by the President of the Boards, the EUIPO Boards of Appeal is a modern dispute resolution hub. And we are offering a wide range of mediation services to businesses and individuals in order to provide to them alternative cost-efficient options that do not involve the risk of solving a dispute in a more formal manner. So for a business and their legal representatives, as well as for any institution that is assisting business owners, it's always valuable to know what the available options are, what effective dispute resolution mechanisms are at disposal, and how and when to use them. So within the context of the EUIPO services, we offer a full mediation toolkit, of course, to businesses and individuals, as well as for their legal representation. In the wake of the COVID-19 crisis, all these mediation services are now offered online. And this is done in order to facilitate the smoothness of the procedures and, of course, to avoid any unnecessary traveling. All the proceedings are conducted remotely through Microsoft Teams or through Zoom or even by phone, if preferred, or any other solution that may be convenient. Moreover, in proceedings before the office, an important aspect is that no additional charges apply. So what are these services that are offered by the EUIPO in the mediation toolkit? The services, as you can see on the screen, are mediation, conciliation, assisted negotiation, which is for SMEs, expert determination, and then a special service that we have set up for SME, which we call the Effective Dispute Resolution Service, or EDR. I will come back to each of these concepts in a moment to explain to you what is underneath. Turning now to the users of the alternative dispute resolution services, so who can use them? In this context, please note that the proceeding must always be an inter partes proceeding, so it must involve two parties in conflict or more, and here, of course, the office cannot be considered as a party. It has to be between two parties in conflict. So if we drill down to the specific proceedings, so when there is an appeal proceeding before the Boards of Appeal of the EUIPO, all users can make use of the alternative dispute resolution services, meaning, of course, also SMEs. And in this regard, I would like to highlight that the Boards of Appeal is the second instance of the office. And in other proceedings than the proceedings before the Boards of Appeal, that is appeals, SMEs can also make use of the effective dispute resolution service that I told you about before. And this service is offered in the first instance proceedings before the office, that is in oppositions and cancellations for the EU trademark, and then also for invalidity procedures for designs, and of course appeals. Let me now give you a brief overview of the mediation toolkit and the specific features and advantages of each technique. So mediation is one of the most used alternative dispute resolution mechanisms. The conflict resolution is designed to lead to a mutually beneficial compromise. And for this, it involves distinct stages that my colleagues will explain in detail later this morning. The mediator will guide the parties in the dispute through the process in order to try and reach an amicable settlement of the differences pending at the EUIPO and, as the case may be, elsewhere. This may come from EU-based businesses or internationally based businesses. In mediation, the mediator does not propose a solution on the substance, but he or she will attempt to identify common grounds and the business interests that may be explored in order to settle the dispute. We'll see more on the roles and the functions of each of the different actors in the next agenda item of this workshop. In the case of conciliation, a conciliator proactively suggests possible solutions to the dispute. These proposals will, of course, be discussed and negotiated, and then, of course, fine-tuned with the parties who remain at all time free to accept or decline the proposed solution. Whatever will be proposed, after thorough analysis of the case, facts, and opportunities, will be discussed and fine-tuned with the parties. Very important for mediation and conciliation to be effective, and we will hear more about that later today. The parties must come to the meetings with the mediator, and they should be represented by a person who has the authority to take decisions on behalf of the company on the aspects of the conflict. That is either the owner, the CEO, or otherwise a person with the authority to take decisions. It is not compulsory to come to the mediation or the conciliation with a legal counsel, but in many cases, this has shown to be very useful. In any case, we would indeed recommend parties to consider be assisted by their legal counsel. The expert determination is an option of an expert that will help reach a settlement agreement between the parties. So here, the parties can jointly and voluntarily decide to opt for expert determination. In this case, an expert can be appointed by the parties to a dispute, and this expert will give a binding or non-binding opinion on a specific aspect, which normally will be a technical or legal issue that is difficult to agree upon without expert assistance. Last but not least, the assisted negotiation option is where a facilitator can support an unrepresented SME by coaching on strategy in the background, but without the facilitator being engaged in any direct negotiations with the party to reach an amicable settlement. So the facilitator in this case acts as a mentor of the SME and does not take part in the negotiation process, but recommends the strategy to follow in case of mediation or conciliation. These services that I just explained could be applied alone or in combination, which is what we call hybrid. For example, an expert determination can be called upon within the context of mediation. Let me now briefly describe the special service provided to SMEs that we call the EDR, Effective Dispute Resolution, that is offered since the 1st of July last year. This is a pilot initiative that is run in conjunction with the EUIPO SME program. For the proceedings that we talked about earlier, opposition, cancellation, and design and validity and appeals, an SME can ask the EUIPO to designate a case handler to guide it through the amicable resolution possibilities available. The objective is to find the most time and cost-effective process in terms of alternative dispute resolution to avoid complex litigation proceedings and draining resources and acting as an obstacle to business. Again, the process is completed remotely and online, and again, no additional charges have to be paid. How does this work in practice? Well, you have on the website a very simple application form that the businesses can fill in without a couple of minutes. After filling it in, it will be handed over to a case handler from the service, and then the case handler would contact the SME to try to obtain a global picture of the background, and then the case handler will give a non-binding recommendation on how the dispute dispute might be efficiently settled, either through mediation, conciliation, or other services. All this information and more can be found on the ADR website of the EUIPO, and we also include a functional mailbox that you can see on the screen, through which we reply to queries and questions every day. And with this, I end you my presentation, and I thank you for your attention for this first item. So let us now continue with the next items of this session. Under the second item, Mrs. Natalia Kapinanaki, member of the ADR service and also an accredited mediator, will guide you through the role of the different actors in mediation. As a general principle, and taking into account the full program for today and the time constraints, I will open the floor for questions as indicated on the agenda, that is, so that all the content may be presented for each session, and then I will open the floor. I will do my best to keep to the timing with your kind help. So Natalia, please, the floor is yours. Thank you.
In this second item of today's agenda, we will go through the role of the different actors in mediation. So this is the four main actors that we can find in mediation is, first of all, of course, the mediator. Second, the parties that participate in the mediation, the lawyers, legal representatives of the parties, and also we will explore the case of having co-mediators. I would like to mention that in the second session of today's seminar, my colleagues, EUIPO colleagues, will also refer into more details in the role of the mediator and the role of the lawyers. So the role of the mediator, of course, is to assist the parties in reaching a voluntary and mutually satisfactory settlement. So the role of the mediator, we can say that is the role of a process manager and the one who facilitates the communication between the parties. Therefore, the mediator is responsible for the conduct, the overall conduct of the mediation. She or he describes the process to the parties, answer questions that the parties might have, and also of course hosts the meetings that will be held during the mediation. On the contrary, the mediator has no authority to settle the case. Therefore, the mediator should refrain from giving any legal advice or playing the role of representing any of the parties. The specific actions that the mediator as a process manager of the mediation has to undertake can be listed as the following. So the mediator should help the parties to capture the overall picture of the situation. That is to, and in that way, enable the parties to rethink their case from another perspective. The mediator also assists the parties in preparing the offers and evaluates together with the parties how these offers will be received by the other party. Also, mediator has to identify objective criteria for possible solutions of the dispute, which means to identify common grounds and the scope for areas of agreement between the parties. The mediator also has to manage expectations and reaction and the reactions from the parties. So he or she needs to help parties to see realistically, in a realistic way, the dispute, and in that sense, to explore outcomes and the related risks to those outcomes. Of course, the mediator will not be liable to any of the parties for the outcome, for for the outcome of the mediation, because it is the parties that decide the outcome, and the mediator in that sense will not be liable for the legality and the enforceability of the settlement agreement. So regarding the parties and the lawyers, we can say that the main concerns of the parties can be synthesized in the following. So the parties are mainly involved in the preparation of the process. They also have questions, and they are concerned about the cost, of course, of the process, and they pay a lot of attention, of course, in the success of the process, and also they are main factors of the success of the process. The lawyers are also are mainly involved in the following, for of course the legal aspects, so taking care of all the related legal aspects. They also prepare and draft the relevant documents that should be also shared with the mediator or the other party. And also they participate actively in the drafting of the settlement agreement. In particular, the parties that participate in a mediation are the ones that decide on the outcome of the mediation. So therefore, as Kirsten already mentioned, they should have full authority to settle the case. In that sense, any person that needs to be consulted during the mediation should be available, and it is recommended that people that can indeed have the authority to make decision participate in the mediation. The second element of the role is, of course, to provide the mediator with a summary of the background of the dispute before the mediation takes place. Also, they need to cooperate actively with the mediator in order to ensure that all efforts are made to reach an amicable settlement to the dispute as soon as possible. They also prepare the first offers. They need to rethink also sometimes their expectations and to think over the best alternative to a negotiated agreement or the worst alternative to a negotiated agreement, and ask themselves the question, what will happen if finally the agreement is not reached? And of course, in that sense, reconsider their positions. The lawyers help the clients, of course, in the different stages of the process. For example, they help the parties to select a mediator, or they help the parties to prepare offers, or to prepare the opening statements of the parties, which is the first part of the process of the mediation. Also, of course, as we mentioned, they need to prepare the case. They need to prepare the documents, the summary, the case summary, and other documents that need to be shared either with the mediator and with the other party. Of course, they prepare actively and they give advice on the drafting of the settlement agreement. And it is very important to say that they should also help their client to identify strengths and weaknesses in their case, and in that sense also advise the client throughout the mediation, and potentially also lead the discussions on the settlement negotiations. There is also the possibility, instead of having one mediator, to have two or more mediators. So this process is called co-mediation, and the mediators, co-mediators, working together on a specific case. Of course, both of them, they are chosen, as for the case of mediator, they are chosen freely by the parties. So there are some cases where co-mediation may be useful. This is, for example, in case we have a complex dispute, or we have a dispute in which one mediator with his skills and experience cannot cover the range of skills needed for this specific case. So in that case, we will be needing a second person to cover the whole range of skills. And regarding the language, if the parties may prefer, for example, to have two mediators that each of whom are native speakers in the specific language of the parties, in case the parties they would like they speak different languages. So the co-mediators should act, of course, as a team, should help each other, complement each other, and it is also recommended in that case that they agree on specific issues beforehand, before the start of the mediation, and that is to specify who is doing what, so which is the role of and the specific task of each co-mediator. They could also they should also ensure that there is fluid communication and active cooperation during the different steps of the process between them. And also they should also, it is recommended that they discuss on the management, the handling of the process in case they have a different use. So concretely how to handle a case where that comes up where there are different opinions between them, and how to handle this. For example, to agree beforehand that they will organize a private meeting to resolve the issue and move forward. So with that, I would like to thank you for your attention, and this is the end of my presentation.
The third item of this session will be presented by Javier Soriano, member of the ADRS and accredited mediator. It will consist of a synthetic analysis of key points of a successful mediation, such as the criteria for identifying situations favoring mediation. I give the floor to Javier Soriano.
Thank you very much. So this, good morning, everybody, or should I say good afternoon to our friends in Tbilisi. In fact, the presentation will be shared between Natalia and myself. Natalia will start giving an introduction on the different aspects of the criteria to identify situations favoring mediation or other ADR solutions. And I will then take over to explain a little bit the procedural steps of the mediation process, and also some of the resources, the useful resources of the EUIPO that are available for our users. So I will give first the floor to Natalia for the first part of this presentation.
Yes, so in EUIPO, we consider that all cases can be subject to mediation. However, it is true that there are cases that present elements that favor even more the mediation as an alternative dispute resolution way of working out a dispute. So I will present some of the criteria to identify now situations that favoring mediation. And the first type of criteria concerns the nature of the specific cause. So the cases that the cases in which mediation is more favorable is where a judgment is difficult to enforce. And when we say difficult to enforce, that may be a difficulty of implementation, lack of resources, or financial instability of the actors involved, and other reasons that make the judgment difficult to enforce. The dispute, another criteria that can be checked in order to see whether a case is more favorable to be resolved through mediation, is that the dispute only represents a part of the underlying or not expressed conflicts between the parties, which means that through the mediation, a global solution can be found. Another criteria will be that there is a need for a tailored approach that recognizes all the interest of the parties, the underlying emotional issues involved, and therefore mediation in that case can offer a more complete solution. And a fourth criterion can be that there is a possibility of coexistence of rights, and this is the case that the markets of both parties have been considered into and taken into account territories, goods, and services. And in that case, also mediation may seem like a good solution forward. So regarding there are also criteria that concern the legal framework of a specific case, and this criteria, this is, for example, when there is no impediment or obstacle to the parties being referred to mediation at the specific stage where the proceedings where the case is, or there are pending proceedings that involve the same parties, and of course in that case the mediation can, as we said, offer a more global solution. It is also the case where favorable to mediation, where there are third parties that will be required to join the action, and of course which would mean more money and more resources, and mediation also can provide a better solution there. And there is also the case of an existence of a mediation clause. For example, a contract between the parties that already contains a mediation clause and provides as a solution of disputes, a future dispute between the parties, the mediation as a roadmap. Thank you.
Okay, thank you very much, Natalia. Well, in my presentation now, we are going to look at the basic steps of the mediation process. Now, Natalia has given us a very good introduction on the role of the different actors in the mediation and how to identify those situations that favor mediation or other ADR solutions. Now, what I would like to give you is more detail about the different steps of the process itself. We will see all of this more in depth in the second session after our presentations, after the coffee break. So, but for the moment, we would like to show you the overall process. We have grouped in this slide the steps of our mediation process into three basic stages. First, the initiation, that is how can the mediation be triggered. Second, the preparation phase, and third, the mediation day itself. So how do we start the process? How is the whole process initiated? We have three ways in which a mediation can start. Either one of the parties makes a request. Second way is when both parties jointly make a request for mediation. Or the third option is when the rapporteur of the case can propose the mediation process to the parties. And remember that this is a voluntary and consensual process. It's just a suggestion and a proposal. So for the unilateral request, obviously it's when one of the parties asks for the mediation, and since it's voluntary and it has to be accepted by both of the parties, we need to transmit this request to the other party. Now, I would like to mention that we also have the role of a reporting mediator that can follow up and inform the other party about the process, so they can really make an informed decision on whether or not to agree to the request made by the first party. And this is useful in the sense that very often parties and the representatives are not aware of the possibility. So it's always interesting to have this figure and this role, which is being very useful to try and convince or explain the benefits of the mediation. Well, now, if the other party accepts, then the mediation process will start. And if not, the normal appeal proceedings will resume. The other possibility I mentioned is the joint request, and logically, this is the most straightforward case. Parties have agreed to mediate, and they send a joint request form for mediation with the details such as the contacts of the parties and the appeal number. And very important at this point is that they need to choose a mediator from our list. Sometimes this will mean that they will need the assistance from us, from the ADR service, which would help them to select an appropriate mediator based on the language of the mediation or a specific expertise that is necessary or very useful for the case. At this point, the appeal proceedings will be suspended while the mediation process is ongoing. And then the other possibility is, as I mentioned before, when the rapporteur, which is the board member that is responsible for the case in the appeal proceedings, after reviewing the case file, considers that it can be a good candidate for mediation. He or she will take into account criteria like mentioned before by Natalia. And other elements that can be conducive to the fact that the case is a good candidate for a mediation. Well, in such a case, a communication is sent to both parties proposing mediation. And here again, the reporting mediator will play a role of guiding the parties to support their decision. The first contact will normally be with lawyers unless the end client is unrepresented, meaning in this case, the lawyer should be seen, and we saw before with the role of different actors. The lawyer can be seen as the key sometimes to the whole mediation process, and this is very important for us to provide with all the necessary information about the benefits and the advantages of mediation, if that's the case. Well, then, if the parties agree, then it's a similar scenario to the joint request. Mediation will start. Otherwise, if one or both of the parties do not accept, then the normal appeal proceedings will resume. But let me say a few words about the choice of the mediator. Now, we have on our website a list of EUIPO mediators. And as you know, in our case, mediation is carried out with our internal mediators. And this means also that we can offer the service without cost for the parties. This list has the CVs, the curriculum vitae of the mediators, including the relevant experience, the training, and languages. And as I already mentioned, when the parties have difficulties to make a selection, we can assist them to select an appropriate profile. So the mediation process has been triggered. Then the next phase is the planning, the preparation. We have a couple of steps here. The first one would be the pre-mediation planning. What we do here is that the mediator will send the parties an introductory email where we would ask the parties when and where they wish the mediation to take place. Physically, this can be either in Alicante, in our headquarters, or our Brussels office, or online. Obviously, for the moment, everything is online. So the actual physical location is not an issue. And we expect this to be the preferred option even after the pandemic. Usually, the mediation will be one day, but it can be more. And with online mediation, we can be a little bit more flexible than with presential meetings, which obviously will favor to concentrate the whole mediation day in one day. So it is very important here to identify the attendees at the mediation and that the decision takers, and this was mentioned before by Natalia, but we will repeat this many times during the day, that is the persons with a sufficient authority to make binding agreements are present. We send the mediation agreement template for the signature of the parties also, and we request as well a summary of the case that contains the facts that are relevant to the dispute according to the parties. During this phase also we need to further follow up with the parties. The mediator calls directly first the representatives of the parties individually to, number one, clarify the points that were made in the introduction, in the introductory letter that I mentioned before, and also responding to any questions that they may have. Number two, we explain the process that will be followed during the mediation day, so they are prepared, they know what's going to come, and then we'll remind them on the importance to block the whole day for that mediation day. It's very important. Sometimes the parties are very busy, not just the lawyers, but also the decision makers in the companies. And it's important to stress that they need to devote sufficient time to carry out the mediation, otherwise it will not work. Number three, this is also an opportunity to find more about the key points of the case summary, including the history of past negotiations or ideas they may already have for settlement separately. We continue the contacts. It's normally necessary to follow up with a number of calls to the parties, both representatives and clients, and this is what is summarized in this slide. First, we need to make sure that the right people, again, sit at the table and stay for the duration of the session. Second, this is also a period to establish a rapport, that is, to build confidence and trust with the parties and their clients. It's very important that the parties trust the mediator and that they trust the mediation process. Otherwise, again, this won't work. It's important to reinforce the message that the mediator is working diligently towards conducting the process efficiently, professionally, and in the best interest of the parties. And this is also an opportunity to start preparing the field to get the parties move their focus from past conflicts to look forward to possible solutions that can be efficient and sustainable. And at the end of the day, we can see this as a change of mindset, a start to preparing them, to coaching the parties, so that they arrive into the mediation with the right attitude, with the right approach to get the best out of the mediation process. Of course, we arrive to the big day, the mediation day itself. And here we can break it down into 4 main steps that are typically followed. I should say that this is a kind of organic process. It's not a strict and very, very rigid process. However, there are typical steps that we cannot bypass. In the presentations after the coffee break, and in particular in session 7 on the mediation working methodology, you'll be able to see the main aspects in more depth. I will quickly, as I said, describe the process here rather than the techniques applied by the mediator conducting the process. Now, the mediation day starts by a joint meeting in which the parties sit with the mediator, and the mediator starts by explaining her role or his role, the main principles and rules of the mediation process, and always reminding about the confidentiality principle. Then we allocate a specific time for the parties to each make their opening statements, in which they express their main points and concerns. And it's very important during the opening statements that, well, the parties, we try to have the parties listen attentively to what the other parties say. Although sometimes it's inevitable that there will be interruptions, we allow for a degree of expression, but we should always remind the parties to wait for their turn until they can talk. After these opening statements, there will be already initial comments and discussions on the basis of these statements. And the mediator's role is to conduct the parties to try already and identify a common list of the issues that should be tackled during the mediation day. With that type of initial agenda, we enter into a series of private meetings of the mediator with each of the parties, typically the client and her or his lawyer. This is an exploration phase where the mediator can dig deeper into the facts and issues that have been identified previously, and in particular that could be the interest behind the positions taken by the parties. The mediator tries to move the parties again towards looking at the future. After this phase, we will move on to the bargaining or negotiation phase, where the parties are actually starting to formulate offers. These parts should be very carefully managed. In particular, help the parties see how the other party would react to the offers that are may be basically unrealistic, or this is a work that, as it will be explained later with techniques, the mediator should handle properly to avoid things like what we call insulting offers, or situations that could not be conducive to a friendly settlement at the end of the day. So in essence, the mediator in this phase is having separate meetings to get the parties gradually come up with workable solutions in a totally confidential setting that will be confidential unless the mediator gets the authorization to convey relevant information to the other party that will facilitate the mediation process in order to approximate and get positions closer. Now, these private sessions will be combined with joint sessions, in particular when the negotiation and the bargaining phase is advanced. And this can be productive in the sense that parties can get together to acknowledge the progress that has been made during the day. And this can enhance also a sense of common achievement, which will, at the end of the day, support the advance in remaining points of discussion. Here, the focus is looking ways or for example, making the pie bigger for both parties. In other words, bigger gains by finding together creative solutions to problems that can, solutions to those problems that will work for both parties. Then, after the process of bargaining and in the concluding phase, we will have hopefully reached an agreement on the main issues that satisfy the parties. This agreement should be workable and should minimize the possibility of future disputes. And it's here where it's very important to draft the heads of the agreement. That is, the main points of agreement or a memorandum of understanding. And this should be done while the parties are at the mediation table. We shouldn't allow that they leave without getting the key points agreed on in writing. Now, the role of the lawyers will be fundamental here in finalizing the detailed terms of the agreement. Before concluding, the next steps of the process should be explained by the mediator very clearly. And if there is any need for any follow-up on the agreement and what we can call ending well, if possible, in a joint meeting where people can, well, say farewell together and live in a, let's say, in a good mood and in a positive, constructive rapport. In case of agreement, this will lead to the formal closure of the litigious proceedings before us. And in case there is no agreement, then the normal proceedings would resume before the Boards of Appeal of the EUIPO. And as indicated in this slide, in keeping with strict confidentiality, the mediator, and this is very important to always remember, will destroy all the notes taken during the process. So that's about the phases of the process. As I said, this will be looked at in depth in terms of the techniques applied by the mediator by our colleagues in the second part of the sessions today. Now, let me move a bit rapidly on the resources that the EUIPO offer through the website to the interested parties that are considering ADR potentially. Well, first of all, the point of entry is our website. At the EUIPO website, you can see in the red arrow there, I'm afraid it's a bit tiny, but it's the access to the ADR service. Once you access to this section, you enter to the information on the ADR service. you can find, first of all, the types of ADR services that we offer, and that were summarized by Kirsten Bauch at the beginning of the presentation. We have the information on the mediation, conciliation, assisted negotiation, and expert determination. For each of those services, it's a collapsible box. And for instance, you have the information on conciliation there. There's a little explanation. And you will, of course, find the relevant documentations, the decision of the presidium, the request form for the parties to request conciliation, and also confidentiality agreement. Depending on each of the services that we provide, you can find different information relevant to this type of service. Now, the idea is that this is as accessible as possible. This is in 5 languages, in the 5 working languages of the office. The next useful information that we make available very transparently to the users is the CVs of the mediators. You can see there our flamant, fantastic mediators there. The basic information on their nationality and the languages they speak, and also links to their CV. The curriculum vitae that contains the information I mentioned before about relevant academic and professional background, as well as the languages, which is very, very useful for the parties to make a choice of the mediator when they are initiating the process. Other resources that we make available to the users, one is the model ADR contractual clauses. This is actually very useful, and it's very recently uploaded there, have been developed so the parties can include the appropriate clauses into their commercial contracts in connection with IP rights. So before any dispute may arise, they are already agreeing in their contracts to solve their differences via a mediation or an ADR technique, the appropriate ADR technique. This was drafted with the support of experts of the ADR Stakeholder Advisory Board, and was drafted to reflect best practices nowadays. So we recommend everybody to take a look and use it or consider its use in order to, from the beginning of the commercial relationship, consider mediation, ADR, as the suitable solution to their disputes. Then we also have information about the networks that the Boards of Appeal ADR have set up to further develop the promotion of ADR with stakeholders. I mentioned a moment ago the Stakeholder Advisory Board. These are networks that get together stakeholders such as other mediation centers, business organizations, intellectual property user associations. We have also a network of chambers of commerce, and very importantly as well, with judges of the EU trademark and register community design courts. There's more. We have also on the website the pledges, the ADR pledges. These are commitments, so to speak, for user associations, entities, business organizations that seek to encourage the use of mediation and other ADR mechanisms. These pledges are useful in the sense that we get these stakeholders to promote towards their members the use or the consideration of the use of mediation and ADR. And they are in 23 languages, and they are designed for different types of organizations, as you can see in the slide. Well, finally, we also have divulgative information, brochures. Apart from the website, people like sometimes brochures. So we have a general ADR brochure and also a mediation brochure with more in-depth information about the mediation mechanism. And that's from my side. I thank you very much for your attention and your patience with me. And I would then pass the floor to the next speaker. Thank you very much.
And finally, the session will close with a fourth item, a presentation of the principles of the mediation process, also presented by Natalia. Natalia, you have the floor.
So after the overall presentation of the process that we use for our mediation here in EUIPO, given by Javier, I will just go through with you to present the principles that are in this mediation process. So the main principles of the mediation process as applied by the Boards of Appeal of the EUIPO can be summarized in the following. So first of all, the process is confidential. Second, as already been mentioned by my colleagues, the participation in the process is completely voluntary, and also the process is not strict in terms of procedure. So there is flexibility regarding the organization of the process. Another very important principle is the independence of the mediator participating in the process, his or her impartiality, and also something that has been mentioned, the fact that there are no additional fees for the mediation process, only the appeal proceedings fees that need to be paid. So let's have a look in particular in each of these principles. According to the rules of the Presidium decision, as well as the BOA rules on mediation, the discussions and the negotiations conducted within the framework of mediation are confidential, not only for the parties, but for all persons, including, of course, the mediator involved in the mediation. And this cannot affect the parties' legal position. Of course, there should be no disclosure of such information obtained through mediation in any judicial, arbitration, or other type of proceedings. In that sense, and the consequence of that is that the mediator cannot be a witness or produce any evidence in litigation, arbitration, or formal or any other formal and give information in connection with the specific dispute and the specific mediation process. In that sense, there is a confidentiality agreement that is signed before the initiation of the process of mediation, and it is signed by the parties, by the mediator, and of course, by any other person attending the mediation, for example, the lawyers, the legal representatives, and just before the start of the process. What is considered to be confidential information? So confidential information, it covers, the notion of confidential information covers all type of information related to mediation, such as the request itself for starting a mediation, either it's a unilateral, as Javier explained, or joint request, the entire mediation process, and even the existence of the mediation itself. Of course, it covers the outcome of the mediation, but also any opinion or suggestion that has been heard or discussed during mediation. So there is, of course, prohibition of dissemination of any of such information that will explain outside the context of mediation. And as Javier also explained, it's very important that one of the last steps at the end of the procedure is that destruction and the deletion of materials that have been obtained or created for the purpose of the mediation. So the voluntary character is, of course, established by the voluntary participation in the process of mediation. So the parties participate only if they want to. As it has been already explained, it can be, the rapporteur can invite the parties, or the parties can request, but it's always, of course, on their initiative. And also this means that the participation is voluntary during the whole process of the mediation, which means concretely that the parties may decide to stop mediation in whatever moment they consider pertinent. The flexibility of the process is reflected also by the fact that the parties can choose the mediator and the language of the mediation, and also the flexibility is reflected by the fact that there are no strict procedural rules. Of course, there is some organic procedure, as Javier mentioned, that needs to be followed, but no strict procedural rules to be followed. The parties are the ones that decide on the outcome and the settlement of the dispute. So it's again the expression of the voluntary character to adhere to what it was discussed. And as already mentioned, the mediator is just a process manager in the sense that mediator helps the party in reaching the satisfactory settlement, a voluntary satisfactory settlement, but mediator does not impose a specific solution to the dispute. A very important principle in our EUIPO mediation process is the independence and neutrality of the mediator, and this is reflected in Article 3 of the Boards of Appeal Presidium decision on mediation. So according to this, before the mediation, examiners, members of the opposing divisions, the cancellation divisions, invalidity divisions, as well as the Board of Appeals, or any other person that has been involved in the decision taking in this specific case, may not be designated as mediator if he has a personal interest or, of course, has previously involved in the case under appeal. So this is before the case comes up to the Boards of Appeal. After and before the process of mediation. After the process of mediation, the mediator that has been involved in that has been handling a specific mediation process should not be in the future involved as an examiner, member of the opposition divisions, cancellation divisions, invalidity divisions, or boards of appeal, of a specific board of appeal, in any further proceedings that have to do with, that are related to the specific case. So, which completely means that in case, for example, for an unsuccessful mediation process, the mediator, of course, should refrain from continuing working on the specific case. This obligation, the independence and neutrality obligation, are principles that are established and have to be respected throughout the process of mediation. So if something comes up, if a specific circumstance comes up during the process of the mediator must disclose any such circumstance that gave rise to a conflict of interest. For example, any personal or business relationship with one or more of the parties, or an involvement as a representative, legal advisor, decision taker of the specific contested decision that goes in the specific dispute that goes through mediation, or if the mediator has worked as an assistant or a member of the appeal, a member of the boards of appeal in the appeal in dispute. So there is the possibility that, again, as we said, is the parties that decide on the mediator. They have expressively agreed in writing to the appointment of this specific mediator. In this case, the mediator may continue with the process. But again, as we already mentioned, it's up to the parties to consider the specific case. So another principle is the impartiality of the mediator, as I mentioned. So the mediator should act impartially and also not only act, but also be impartial throughout the process, which means concretely to avoid assumptions towards positions and interests or the overall perspective presented by a specific party, and also, of course, avoid being judgmental. In that way, so being impartial and being non-judgmental, the mediator also builds trust with the parties in his relationship with the parties. So the last principle is that we do not have additional fees. So if the mediation is held online or, of course, at the EUIPO premises here in Alicante, there are no additional fees other than the appeal proceedings fees. If the mediation is held at the EUIPO premises in Brussels, in that case, an administrative fee of 750 euro has to be paid in order to cover for the travel and the expenses of the mediators. Thank you very much for your attention.
Thank you, Natalia. Thank you, Javier, for your presentations. And I will now open the floor for any questions on these presentations about mediation techniques, roles of actors in mediation, key to successful mediation, and the principles of the mediation process. So if you wish, you can raise your hand. I have one question through the chat about unsuccessful mediation. Can it still be useful to have the mediation, bearing in mind that the mediation process is confidential? And we have further questions. So meaning that the parties cannot rely on any document within the process and the facts agreed upon the mediation.
Okay, well, maybe Natalia would like to chip in, but for the first question, can it be still useful, bearing in mind that the mediation process is confidential, and after the clarification, meaning the parties cannot rely on any document within the process, the facts agreed upon the mediation, what is, well, if the mediation is unsuccessful, then the usual proceedings resume. And indeed, the information that was shared during the mediation was confidential. So it's independent in that sense from what is going to happen afterwards. And I don't know if that replies the question properly. In what sense is it useful, the mediation? Is that the question?
Thank you, Javier. I think that Mr. Gordon Humphries could add very useful information on this point. Gordon, you have the floor.
What I'd like to say is that it does have its use because it helps the parties to clarify the issues. And often it helps them think about what their real business interests are. It's surprising how many businesses actually don't really have such a clear idea of where they're headed in commercial terms with the dispute, what they want out of it. And this is very useful to have the mediation because they then get a clear idea. And it quite frequently happens that although they don't make a settlement on the day, they do actually go away and talk with each other and come to an agreement by themselves afterwards. So that can be very useful. What we have to be careful about, and I think this is what the question is talking about, is people that come to the mediation, let's say, not in good faith, but with a view to a fishing expedition to get information about the other side. I have to say that this rarely, if ever, happens because it very soon becomes apparent if somebody has no interest. Okay, I don't know how much. I hope I didn't get cut off too much with that, but that's what I wanted to say. Thank you.
Thank you, Gordon. I think this the quality both of the reply and of the connection were perfect in this sense. Now we go to a next question, which is how long does the process of mediation usually last? And I would like to call upon Sven Sturman, chairperson of the Boards of Appeal, to reply on this one.
Yeah, thank you very much, Kirsten. Good morning. Good morning, everyone. Yes, I mean, the length of the mediation process depends very much on the specific case. And let's say from our side, we are always very flexible. We can start immediately once the mediation has been requested by both parties, and we will do always our utmost to be as agile and quick as possible. But don't forget that first, if you have complex cases, the parties need to prepare together with the lawyers the mediation process. You need to fix a date, to find a date which is suitable to everyone. I mean, even if you do it online, if you do it offline, meaning you meet in a specific venue, then of course it becomes even a bit more complicated. So all in all, I would say that at least you need to calculate, let's say 2 to 3 months if it's a straightforward case and parties are available on a specific date. But we also have had mediation which take much more than half a year or even more. It depends very much on the case. And but let's say from our side, the idea is to offer a quick service and to make it as soon as possible. But again, it depends very much on the facts. But I would say between 2 months, 3 months, and a year, it should be feasible.
Thank you so much, Sven. The next question is, what are the statistics of the processes that we have just explained of all the ADR mechanisms? Since 2012, we've had about more than 500 cases. Out of these, around 200 went accepted by the parties, and there was a positive outcome in around 70+% of the cases. So those are roughly. So when the parties really do agree to proceed to use this this mechanism for solving the disputes, the probability of solving it in an amicable manner are effectively quite high. I hope that this answers the question. Otherwise, we can give you more details on this. Another question is about the respect to the roles of the parties. So there was one of the slides referred to as BATNA and WATNA. So what are these abbreviations stand for? And this was, if I remember well, Natalia.
Yes, it is already answered by a colleague in written in the chat, but it's BATNA, it stands for Best Alternative to a Negotiated Agreement. And WATNA stands for Worst Alternative to a Negotiated Agreement. It's a way of reminding and thinking and discussing with the parties to see what will happen in case there is the agreement, the mediation process is unsuccessful, and through this discussion, the parties can realize and take a more realistic view of the whole case and see it probably through another perspective. I think that in the second session, there will be more discussion also about this.
Thank you, Natalia. There are no further questions as far as I can see in the chat. So I see Sven wants to take the floor. Sven Sturman, please.
Yeah, Kirsten, very briefly, because there was this question on confidentiality, which I think is a very important issue, and I think we haven't really replied to that one. So 2 issues here. I mean, first of all, the process, as Natalia and Javier has said, is strictly confidential, which is an essential requirement and also a big advantage of the mediation. But at the same time, you need to be very realistic, because if you do the mediations, the parties will come all the time and say, oh, this is very confidential, you can't disclose that to the other party. And then you actually notice that this is common ground. You either found it already in the observations exchange between the parties, or it's even available on the internet. So what I want to say with that is, whenever you hear confidentiality, the first thing is you need to really check if it's true that it is confidential. Yeah, so you need to check And that's why important. You need to prepare the mediation with great care, and you need to know all the documentation exchange, and then you need to see if the facts discussed are really confidential or not, because you will see in 90% nothing is confidential because it's either in the public domain and internet or it was exchanged by the parties. And on the second point, if something is really confidential, which will usually happen at a later stage, not at the beginning, but if you continue with the discussions and negotiations at some point, and you will see that they come up with confidential information, it's true confidential information. First, that gives you a hint that you're on the right track. Because if you don't get any confidential information, you know that you're not on the right track, because there's always confidential information. So when you see that the parties give you really confidential information, you know that you are doing the mediation in the correct way. Then, of course, you need to discuss it with them, you need to keep it confidential, but at the same time, you need to explain to parties that at some point they need to reveal this information, because you can't, let's say it's very difficult to negotiate if you don't reveal and make available important information to the other parties. And then you can either suggest to the parties that you, let's say, summarize this information at a higher level, and you address not the exact fact which is confidential, but the interests which are behind, and you reveal then the interest. That's one possibility as a technique. Or you ask the parties if they could agree to actually make this information available. So confidentiality is very important. It's very tricky, but you need to use a lot of common sense, because otherwise you will not be able to move forward in negotiations. Thank you.
Thank you, Sven, for highlighting these practicalities that, of course, they stem from common sense, but we also need to take them into account for the very tricky aspect of confidentiality. I can see no further question. We have one further question. So how are mediation agreements enforced, please, once reached? So that goes for the part that is after the settlement agreement, and when this is looking forward in the future. So that is after the action of the mediator. Yes, Gordon, please, you have the floor.
Okay, thank you, Kirsten. Well, I mean, the starting point is what is provided for in the settlement agreement. I think what we're talking about here is not so much the mediation agreement, just to clarify terminology, is the agreement by which the parties undertake to mediate the case, right? Now, this is not really, there's not really a question of enforcement there, because mediation's a voluntary process. So if at any time the parties decide they don't want to mediate, then that agreement falls and the mediation process stops. I think what is meant here is the settlement agreement. So the settlement agreement, certainly, and I'll be explaining this a bit later on, so I won't go into too much detail, but there are cases when you make the settlement agreement by which the agreement will be enforced. So it's very important to foresee an applicable law clause and a jurisdiction clause, right? Now, the reality at the EUIPO is that a lot of the parties that come before us are, at least one of them is not from the European Union. So you have to also take that into consideration. And the applicable law clause should certainly, it's something to be negotiated. But normally, in the mediations I've been involved with, a starting point is, for instance, that the parties say, well, the CEOs of both companies, in the event of any future problem, the first thing they will do is they will talk to each other and try and find a solution. If they can't do that, then there may be a follow-up clause that says they will come back for more mediation. So they will come back and have another round of mediation. It can also be in an international context that they foresee an arbitration. I had a case where they foresaw the possibility of the Vienna arbitration chamber. in order to in the event of any future dispute. And that's quite useful where the parties are obviously from different countries, and they mistrust the courts and legal system of each other. So all these mechanisms, I mean, there are many solutions that are possible. And if you were lucky enough to have a dispute between a Chinese and an American over that was in a European context, you would also have the Singapore mediation convention, which of the mediated settlement, because both of those countries are signatories of that convention. Thanks.
Thank you, Gordon, for highlighting these aspects. I can see Sven wishing to take the floor.
Yeah, thank you, Kirsten. Very, very briefly. I mean, I agree with what Gordon said. Of course, just one addition. I mean, we in the EUIPO, all the mediation agreements, the settlement agreement, as Gordon has said, the settlement agreements, we are not involved in any kind of enforcement issues. That's very important. The mediator is not signing the settlement agreement. We consider this to be a private contract between the parties. And this, of course, then is to be enforced according to international private enforcement rules. And then, of course, you need to take into consideration the aspects Gordon has just mentioned. But just for you to understand, for us, we are first not part of this agreement. We are not signing it. We are not even asking the party to send it to us. It's just a document, private settlement document exchange between them. And then if they need to enforce it, which we of course hope it's not necessary, then they will need to do it according to international private rules. Thank you.